Form I-130, Form I-140. Concurrent filing with application for adjustment of status or not.
Hello, greetings. I am Attorney Edwin Fogam. I have been practicing immigration and other areas of the law in the United States for the past 28 years. Today, I would like to answer a question that many of our clients and potential clients have been asking, and that is whether they could adjust their status in the United States concurrently with the application for an immigrant visa, either the I-130 or Form I-140. The Form I-130 is the petition that is filed by a family member to obtain a permanent residency for his or her spouse, child under 21, or parent. That is a family-based. Form I-140 is an employment-based petition that is filed by an employer or could be filed by a petitioner if they are not going through their employers under national interest waiver or any other category like that. Now the question becomes, can these petitions be filed concurrently with an application to adjust your status if you are in the United States? Now, an adjustment of status is filed on Form I-485, and that is the application for a green card. So many times, if and when a foreign national is in the United States in valid non-immigrant status, they could file their adjustment of status application along with the petition that is being filed on their behalf. However, this concurrent filing is tricky. There are three questions to ask yourself before you file concurrently. First of all, whether the visas are immediately available. Secondly, whether you are admissible. In other words, are you eligible to obtain adjustment of status in the United States? And thirdly, whether strategically it is even worth doing that based on the petition that you are filing. Now, for I-130 petitions, which are family-based, if you are an immediate relative, that is spouses, parents, or children under 21 of U.S. citizens, it makes sense to file concurrently because visas in these categories are always available. However, if you fall under one of the other preference categories like siblings or filing for permanent residents, filing for their spouses, children, and so on, it doesn't make sense. You cannot file concurrently. That doesn't help you. Now, regarding Form I-140, employment-based visas, there are two things to think about. First of all, are you in valid non-immigrant status? If you are not in a valid non-immigrant status, you cannot change your status in the United States from a non-immigrant, from an out-of-status position to a legal status. You must be changing from a valid non-immigrant status. It is not like an immediate relative petition, family-based, where you can adjust your status if you had entered with inspection. So for I-140s, the two questions come up. One, are you admissible? Are you in valid non-immigrant status? Two, your priority date. Are the visas immediately available in that category? Most employment visas, employment-based visas, EB1, EB2, and so on, EB3, the visa bulletin will state whether the visas are available, whether the priority dates are current. So before you consider filing adjustment of status concurrently in an employment-based category, you have to make sure that is taken care of. So these are the things to think about when you are considering concurrent filing. Filing your petition along with your application for adjustment of status. I hope this information was helpful to you. It can be a little tricky or complex, but that is the essence of it. And if you would like us to help you, please feel free to contact us. Law offices of Fogam and Associates. You can reach us on 301-608-1555. You can also shoot us an email. And please, don't fear the system. understand it, work with it, and benefit from it.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.